On behalf of the American Society of International Law, I'd like to welcome you to our webcast today, The Use of Force Under International Law. I'm Lucinda Lowe, the president of the American Society of International Law, and we are here at Tiller House, the headquarters of the Society in Washington, D.C. Our event today is the 8th in a series the Society has organized on international law and the Trump administration, and the 3rd in a trilogy on security issues that began this past summer and have covered migration, cybersecurity, and related issues. Earlier programs in this series have dealt with international agreements, treaties, trade, the environment, and the UN. They're all available on our website, www.asil.org/Trump, as either a webcast or a podcast free of charge. The Society is a nonpartisan, not-for-profit organization founded in 1906. And our mission is to educate about international law and promote international relations on the basis of law and justice. This webcast is in furtherance of that mission. The series is designed to provide information to people around the world who want to have a better understanding of key issues in the international arena today, particularly focused on international law and institutions. And there is no more significant issue than today's topic. What is international law and the use of force? How effective is it in restraining aggression? What is the interplay between international law, domestic U.S. laws, and the exact actions of our executive branch? We are fortunate to have as today's speakers Jack Goldsmith and Ona Hathaway, people who have deep knowledge about and experience with these issues from having worked on them both in government and in academia. And with our prior programs in this series, our panelists have served in both Republican and Democratic administrations. As our speakers will be introduced by our moderator, I will not go into their backgrounds in detail, but I'd like to thank them and the moderator for joining us today. I would also like to thank the Society's Executive Director, Mark Agrast, and our staff for their work on this project. Let me turn it over now to our moderator, Laura Dickinson, to introduce our speakers. Laura is a professor at George Washington University School of Law, where she teaches in the area that we're going to be discussing today. And she's also served as a special policy advisor at the U.S. Department of State, and more recently as special counsel to the General Counsel of the U.S. Department of Defense. Her teaching, scholarship, and government service all make her ideally suited to lead today's conversation. Laura, over to you.
Thank you, Lucinda, for that introduction. It's my great pleasure to serve as the moderator for this session. And for our discussion today, we have very distinguished panelists with, as Lucinda mentioned, tremendous experience, both as scholars and as practitioners of this body of law at a very, very high level. Jack Goldsmith is the Henry L. Shattuck Professor of Law at Harvard University and a senior fellow at the Hoover Institution. He is the author of numerous books and articles, including most recently, The Terror Presidency, Law and Judgment Inside the Bush Administration. He served as special counsel to the General Counsel of the U.S. Department of Defense from 2002 to 2003, and as Assistant Attorney General in the U.S. Department of Justice Office of Legal Counsel from 2003 to 2004. He is also a founding member and regular contributor to the popular national security blog Lawfare. Ona Hathaway is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School, and she is also a professor of political science at Yale University. She served as special counsel to the General Counsel of the U.S. Department of Defense for National Security Law from 2014 to 2015. She is also the author of numerous books and articles, including, most recently, a book she co-authored with Scott Shapiro, entitled The Internationalists: How a Radical Plan to Outlaw War Remade the World. And she is a frequent contributor to the popular national security blog, Just Security. So the focus of this session is the Trump administration and the use of force under international law. And before we turn to our panelists, I'd like to provide some background on this difficult and timely topic. So from Syria to South Korea, United States armed forces are present around the globe protecting US interests and allies. And the global fight against terrorism has been particularly demanding, with the war in Afghanistan in its 16th year. Yet the United States also faces other threats, such as the rising tensions on the Korean Peninsula. The legal framework under international law for confronting these challenges has arguably never been more relevant than it is today. In particular, the body of law that is the focus of this discussion, the jus ad bellum, the law that governs when states may initiate the use of force, is critically important. So I'd like to begin by asking our panelists to talk briefly about the origins and purpose of this legal framework. And it has very old roots, but in its most recent form was born out of the ashes of World War II and took shape in the United Nations Charter. The US played a leading role in shaping this body of law. So, Ona, since you've done a lot of work recently on this issue, could you start by telling us a bit about the origins of this body of law and its fundamental purpose?
Yeah, I'd be happy to. Thank you so much, Laura and Jack, for this conversation, and to Int'l for hosting us. It's a great opportunity to talk with you about these really important issues. So, of course, today what we look to is Article 2.4 of the UN Charter, which is the prohibition on the use or threat of force by one state to another. And that was part of the UN Charter, passed in 1945, which nearly every nation in the world joined relatively quickly thereafter, and continues to be the central governing rule in this area today. In the book that you just mentioned, part of the work that we do is to show that the UN Charter didn't invent this rule out of thin air. It didn't come just into being in 1945. What's interesting is the origins of it date much earlier, and that is to the much maligned 1928 Calais-Briand Pact, which was the first time the nations of the world assembled together and decided to outlaw war. And that is the central framework of the book, and it is the central beginning point of the book, in part because it's a beginning point of this rule against states using force against other states for the purpose of enforcing the law, for the purpose of righting wrongs. It specifically made clear that the prior rules, which had been in place for hundreds of years, which allowed states actually to choose to use force for a wide range of purposes, debt collection, enforcement of international law, resisting interference with trade relations, wife stealing, but that was no longer going to be the rule, that no longer could states choose unilaterally to resort to force to right wrongs, but that they were going to renounce that right to use force. And the Article 2.4 in the UN Charter is the consolidation and restatement of that principle. And in fact, one of the stories we tell in the book is that the very first draft of the United Nations Charter, which was written by the very same person who ghost wrote the 1928 Calais-Briand Pact. And what is today Article 2.4 really got its start literally with a cutting and pasting of the pact into the first draft of the charter. And so that's really where this comes from. And I think that that background or that understanding of the origin is useful, first of all, because it's relatively new in the history of human relations that we have a prohibition on force. Dates to not to 1945, but to 1928. Even then, it's less than 100 years old. And it's important to recognize that while the charter is the crucial rule that we look to today, it isn't the only place in which the decision was made to outlaw war. In fact, that dates a little bit earlier to this decision in 1928. So that's just a little bit about the beginnings of all of this.
Thanks, Ona. Jack, Ona mentions Article 2.4 of the United Nations. Could you say a little bit about what's in Article 2.4 and more broadly, what the key elements are of this body of law?
Sure. And I also want to thank you two for inviting me to talk today. As Ona said, the central prohibition of the UN Charter comes from Article 2.4. It prohibits the threat or use of force against the territorial integrity or political independence of another state. That is the presumptive kind of default rule that it states right up front. And then there are essentially 3 exceptions, 2 that are written into the charter and 1 that seems to follow naturally from it. The one that's not written in the charter is that one state can always consent if the consent is real and is given by a proper government for another state to use force in its territory for whatever reason. A second basis for is for sort of, I wouldn't say an exception to Article 2.4, but a way to use force consistent with Article 2.4 is if the Security Council authorizes it under Chapter 7. If it finds that the authorization for a use of force would help preserve peace and security, they can do that. And that's happened before, for example, in the 1991 invasion of Iraq, famously. And finally, and most problematically, there's an exception for self-defense. And this is where, I'll read it in a moment, this is where a lot of the weakness in the legal structure, I think, of the Charter has been. And the softness of this exception has been what nations have exploited, or at least used as a means to be able to use force. And Article 51 is where the exception for self-defense is found, and it says, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations." So it seems nothing in the present charter shall impair the inherent right of individual or collective self-defense. That makes it seem like, and many people have interpreted that to mean it was a right that an inherent right that preceded the charter. So that's given people the notion that that's a customary international law rule. Maybe that has more flexibility than the other rules in the charter. There's a condition, though. It says if an armed attack occurs against a member of the United Nations. Excuse me, yes, a member of the United Nations. That sounds like you have to wait for an armed attack to occur before you can exercise in self-defense. Some people still believe that that's the law, but I think that it's fair to say, you can disagree if you want, that the way it's come to be understood is that prohibition allows anticipatory self-defense in accordance with the Caroline standard, basically narrowly understood from the 19th century. And that means that you don't actually have to wait until you're under attack to respond in self-defense, that if the threatened action is actually imminent, and you have no time for thinking and no time for doing anything but react, then at a minimum, Article 51 allows that. But that idea of imminence once that's introduced, that's where a lot of the flexibility has gone, because people in modern times have argued that imminence should be stretched.
Now, one thing you don't mention is humanitarian intervention or humanitarian grounds for action.
I didn't mention it because I don't believe it's an exception to the Charter. The Charter was designed to outlaw uses of force. That was, as Ona's book shows quite well, that was thought to be the main evil in international relations. There are other evils in international relations and in domestic relations. But the Charter by its terms simply doesn't contemplate a humanitarian intervention exception. People have been arguing for it. Some states have openly, the UK recently came out in favor of a limited principle of humanitarian intervention. Many academics have argued for it, but I don't think that there's no textual basis for it. There's not nearly enough practice of nations followed from a sense of legal obligation to kind of override this most fundamental of treaty obligations. Now, that means that, maybe we should change that. Maybe it's appropriate to violate the law in certain circumstances, but the law as it is, I think, is pretty clear.
Do you agree?
I do. I think that it's clear that there are very specific exceptions to the prohibition on use of force, and humanitarian intervention isn't one of them. One of the things that was interesting in delving into the history, so not only the pre-charter practice, but pre-1928 practice, was to discover that actually humanitarian interventions during this early era were relatively common, and that humanitarian reasons were often given by states when they intervened in other states, as they were legally permitted to do before 1928 unilaterally. And they did that alongside claims like debt collection and claims like, collection of compensation for tortious interference and these other kinds of purposes that today we would recognize as illegitimate. And my reading of the history, both in 1928 and in 1945, was that the intention of those who wrote the pact and then wrote the charter was to prohibit states from unilaterally choosing to use force for any purpose that is not specifically laid out in the charter, and the main one being self-defense. That doesn't mean that if you can't get other states to agree to it, that you can't engage in humanitarian intervention. So I think the thought was that there are lots of other purposes that one might have for using force, but you just have to get the Security Council on board with it, as the world did when there was an intervention against the Libyan regime in the face of what was seen as an imminent humanitarian disaster that was authorized by the Security Council. So that's permissible, but it's the Security Council authorization that's necessary. A state can't by itself judge that humanitarian purpose justifies it unilaterally resorting to uses of force.
If I could just say one thing about that. So the veto power among the big five powers in the Security Council thus becomes very important, because if you have to get authorization from the Security Council to be able to use force in a humanitarian situation, any one of those five members can veto that. And as I think in your book you showed, that was a point of contention that almost didn't happen. There almost wasn't the veto power for the big five. But when that was made, it was basically understood, I think quite clearly, that that would be a check, an extra hurdle to authorizing the use of force.
And maybe I'll just say a quick word about that, because I think it's worth saying something. When I delved into this, part of what I was interested in understanding in history is why did they do that? Because today there is a great frustration, I think, for many, that there are times when many of us think, the world should do something. And yet the Security Council won't authorize intervention. And that's a deep frustration. I think that's part of what is driving a lot of this desire to come up with a humanitarian intervention exception to the charter, which I think Jack and I both agree isn't really there. And so part of what I was interested in when I was reading the history of the charter was this just an oversight? Did they not anticipate it? What were they thinking when they put in place the veto for the permanent 5 members? And turns out that it was very much debated, and they understood what they were doing, and they understood that it was going to cause them not to act in cases when many of them thought it was a good idea to act. And yet there are 2 reasons it happened. One was that essentially it was the price of the deal. Stalin wouldn't agree to join the United Nations or create the United Nations if there wasn't a veto. And Roosevelt and Churchill spent a lot of time trying to persuade him otherwise and did not succeed. And they decided it was better to have a United Nations with the Soviet Union in it than without it, and that was a clear price of it. And second, I think they ended up concluding that they didn't want to have a situation where the states that had won World War II were on opposite sides of a conflict. And they understood that if they allowed unilateral recourse to force, you could very well end up in that situation. And so part of the reason Roosevelt and Churchill came around was because they understood that they understood that if they were involved in a conflict that the Soviet Union didn't want, that was likely a path to world war. And that was exactly what they were trying to prevent.
Well, let's turn now to look at how this body of law plays out in some current situations around the world. One of those situations is Syria, where the United States, along with multiple allies, has been fighting against the terrorist organization ISIS through its and in support of its Syrian, Arab, and Kurd allies, the Syrian Democratic Forces, or the SDF. And just a few weeks ago, on October 17, 2017, these U.S.-backed forces seized the Syrian city of Raqqa, which was the ISIS de facto capital. So this was a major blow to ISIS, and ISIS is now retreating into the middle Euphrates Valley. Meanwhile, the United States is combating al-Qaeda in Syria, but at the same time, It is not currently at war with the regime of Bashar al-Assad, the brutal dictator who has committed massive atrocities against his own people and is engaged in a bloody civil war where 500,000 people have died and roughly 5 million people have fled the country. So, Jack, maybe you could start us off. What is the legal basis for U.S. military engagement in Syria against ISIS?
Yep. So we don't have to speculate about this because the United States in 2014, as is required by Article 51, filed a letter with the Security Council explaining the basis for its use of force. And it basically said that the ISIS forces were in safe havens in Syria that were not under the control of the Syrian government, that were essentially ungoverned spaces, that they were using those platforms to threaten and engage in attacks against Iraq, that they were acting in collective self-defense with Iraq, that they were also acting in self-defense because ISIS was threatening the United States. And then they, in explaining their theory of self-defense, they explained that they relied on this theory of unwilling or unable, which is essentially the idea that if a terrorist organization or non-state actors are in one nation and from that nation are threatening or using force against another nation, the nation that is on the receiving end of that force or that threat can engage in self-defense against the private entity, consistent with the UN Charter, if the state itself where the terrorists are harbored is unwilling or unable to stop the uses of force. So the United States relied on that theory. It's a theory that the United States has relied on in different ways for a long time, but it's definitely been relying on it more in the post 9/11 era with terrorist groups camping out in various countries. And I think it's fair to say that slowly but surely over the last 10 years, other nations have joined what used to be a more controversial theory. It's still somewhat contested, but I think the support for it is growing. So essentially, it was a self-defense collective and individual self-defense rationale.
Could you just say a little bit more about how you think it satisfied the imminence requirement in self-defense that you talked about earlier?
So they didn't talk about that in their Article 51 letter, but I assume it's because there were actual attacks coming over from, I mean, you know, ISIS was along that border between Iraq and Syria, and they were using the camps and the locations in Syria to both support their troops in Iraq, and I think to engage in attacks in Iraq. So I think that it was an actual armed attack that they're responding to, or a series of armed attacks that they're responding to. I don't think it was just anticipatory self-defense. I do believe that the individual self-defense claim, I'm speculating here because it wasn't fleshed out, the individual self-defense claim that the United States claimed it was acting in self-defense of its own defense, not in collective self-defense with Iraq against the Islamic State. I think that was more of an anticipatory self-defense idea, although it wasn't fleshed out.
Do you agree, Ona?
Yeah, I think I agree both on the counts. And one, if they're interested, you can go look up the Article 51 letter that was filed and see the arguments that were made. So I think the important point, and Jack said this, and I just want to emphasize it, is that the collective self-defense piece of the argument, I think, was very solid. Yeah. I mean, so Iraq is, you know, its territorial integrity had been violated. The border between Syria and Iraq had been essentially undone by ISIS, and ISIS has lots of videos online showing it sort of, you know, having cleared out the border crossing checkpoints, and they were launching attacks into Iraq. So that piece of it is quite clear. I think the more tenuous part, particularly at the time this initially began, which is in August 2014, of claiming that ISIS posed a threat to the United States directly, was a bit of a harder lift. And part of the difficulty came in the fact that it wasn't clear that much of what we call ISIS aren't really ISIS-inspired people, so not really affiliated with ISIS. And what exactly is ISIS is part of the difficulty. So there are some groups in the United States or individuals in the United States who might declare sympathies with ISIS, but are they really ISIS? And does somebody who's ISIS-inspired and the fact that they might carry out attacks in the United States, is that enough? And And those, as Jack said, that wasn't really fleshed out in any kind of length. The letter's very brief. There wasn't any more detailed legal memo released. So there's not a lot of information about the precise rationale the United States relied on there. But I think most international law observers think that the collective self-defense piece was very solid. The second half, the individual self-defense piece, more tenuous, probably has gotten stronger over time, given that there have been more attacks both in the US and in Europe.
But frankly, at the time, they didn't need the individual piece. It was an argument in the alternative.
Yes, that's right. I think that's exactly right. Yeah.
Ona, could you say a little bit about what you see as the legal basis for the use of force by the United States against al-Qaeda in Syria?
Well, I mean, it's a similar kind of argument, right? So the claim is a self-defense argument resting in part on the 9/11 attacks, a significant part initially on the 9/11 attacks and a variety of other related attacks since then. And, so the decision of the United States to enter Afghanistan was, of course, also premised on the idea of self-defense against al-Qaeda and Taliban affiliated forces. And that continues to this day through a variety of al-Qaeda affiliates. Now, I will say at the time, the idea of self-defense by a state against non-state actors was actually quite controversial. Whether a state really had a right of self-defense against non-state actors was really, I think, not widely accepted. I think has, as Jack said, become more accepted over time. I think there remain some questions, and again, not well specified, as to how long does that right extend? How much of a threat does the group have to continue to pose? Does that right ever expire, and under what circumstances? Problem with a self-defense right against non-state actors, particularly loosely affiliated groups, very hard to know when you've won. Or when you've won enough such that your legal right to use force outside of your borders is extinguished. And I think we haven't really figured that out entirely yet.
I just want to say that especially with the attacks on the Khorasan group, if that's what we're talking about in part, the al-Qaeda affiliate in Syria, the United States did offer some explanations for that, and they were pretty tenuous in terms of how imminent the threat was. The Defense Department spokesman and actually the FBI director at the time basically said we didn't know when the attack was going to come. We didn't know what form it was going to take, but we didn't want to wait for it to develop. So it sounded like a very, very tenuous notion of anticipatory self-defense.
I want to come back to this point of whether or not it ever expires. But before we go there, I want to ask about the United States strike on the Shayrat airfield on April 6, 2017. That was in response not to ISIS or al-Qaeda in Syria, but rather to an attack several days earlier by the Syrian regime, a chemical weapons attack on the Syrian people. And President Trump, in response to that attack by the Syrians, ordered that the United States attack the Shayrat airfield. It was believed to be the launching point for the Syrian regime's chemical weapons attack. And shortly after that strike, U.S. Secretary of Defense Mattis said that, quote, "This military action demonstrates the United States will not passively stand by while Assad blithely ignores international law and employs chemical weapons he had declared destroyed." And the U.S. Defense Department assessed the strike destroyed key assets, including fuel and ammunition sites, and 20% of the Syrian regime's operational aircraft. And just this past week, a United Nations investigative panel confirmed that the Syrian regime had indeed launched this attack, and that the regime had used sarin gas, killing dozens of civilians, including children, and that it was one of the worst chemical attacks in the conflict. So what is the legal basis for this, if any? Jack?
I don't think that the United States had a powerful legal argument under international law. It's clear that what Assad was doing was horrible and was violating international law. But it doesn't follow from that the United States acted lawfully in retaliating or striking him in response to that. It wasn't self-defense. There was no plausible self-defense argument. Some people tried to argue that maybe the development of these weapons might end up eventually hurting someone outside the borders, but that argument was very tenuous. Some people floated the idea that it might be a countermeasure, which is an illegal action, an otherwise illegal action taken in response to an illegal action. But I think it's pretty clear, I'm pretty sure ONA agrees, that countermeasures involving the use of force aren't allowed under the charter. It's simply not allowed after 1945. We've already discussed, so it wasn't self-defense, countermeasure wasn't available. We've also already discussed humanitarian intervention and why we don't think that's available. So that was probably the most powerful argument for it. And some people have argued that this was a humanitarian intervention, and perhaps that was what it was. But as discussed before, I just don't think that's lawful under the charter, as much as people would like it to be. So we have this terrible situation, and the world's not a perfect place, where this terrible action is going on, and it's probably illegal, but it's not lawful to intervene to try to stop it. I think that's the right way to see it.
Do you agree?
I do. And I think there's an irony here, which is international law says you can't use military force to enforce international law. It used to be perfectly legal to use force to enforce international law. In fact, a significant portion of wars were fought for this reason. So it was quite common for states to cite the violation of a treaty obligation or customary international law as a legal justification for going to war. International lawyers today often bemoan the fact that there are difficulties with enforcing international law. Enforcement of international law was quite easy back then because it was enforced with force and with war. That is no longer the case. International law does not create a kind of general permission to use force to enforce the law. Quite the contrary. It specifically prohibits it in Article 2.4. It only allows it for very specific reasons. As we've already noted, Security Council could have authorized an enforcement action, but hadn't and had repeatedly refused to do so. Chemical Weapons Convention itself, which Syria signed actually under duress or under strong pressure, shall we say, does not permit enforcement with military force. And if it did, I would guess very few states would have ratified it to begin with. And countermeasures doctrine clearly doesn't permit it. The draft articles on state responsibility specifically state that countermeasures doctrine does not permit violations of the UN Charter, and Article 2.4 is a core obligation under the UN Charter. So it's clear that as terrible as the things that Assad did were, that international law doesn't permit states to use military force to enforce those obligations.
If I could just add one point. I agree with all of that. It was notable that the world reacted to those strikes with either silence or support. The Russians were upset about it. The Syrians were upset about it. But there was very little condemnation of the United States outside of those two countries, including the Chinese. And not clear what that means. Maybe it means that in this context, compliance with international law isn't the most important thing. Maybe it means that Assad is such a terrible person, people are going to give it a pass. Maybe it means that it's a piece of evidence in favor of a developing norm of humanitarian intervention, as some people think. Maybe it means nothing. It was just pragmatic. But it was noteworthy that there was very little condemnation inside the United States or outside of what Trump did.
So both of you have said you think that the strike was unlawful. So I gather, to the question of whether the United States could use force to oust Assad, who is a brutal dictator and has committed massive atrocities, you would answer it in the same way?
Yeah, I mean, assuming the situation remains as it is and he doesn't pose a direct threat to the United States or to a neighbor who requests assistance lawfully under Article 51, which seems to, at the moment, not be the case. This is, again, it's a core norm of international law, which is you can't just oust leaders unless you can get the UN Security Council on board. And again, UN Security Council has repeatedly refused to authorize any kind of armed intervention into Syria. So if you could get the Chinese and Russians on board, then yes. But until then, unilaterally resorting to force, or even resorting to force together with a coalition of the willing, would be in violation of international law.
And you agree, Jack?
If we're just talking about international law, yes. I mean, that international law prohibits it. Whether that should be the most important norm here is something that people disagree about, but it's very clear that international law doesn't allow that here under the current circumstances.
So, Ona, you mentioned Russia. Russia is an ally of Syria in the conflict there, which further complicates matters. How do you think that affects the legality of our use of force in Syria?
I think it doesn't so much affect the legality as it does affect the possibilities for getting ourselves into a mess. So the Russians, to be clear, just in case listeners aren't aware of this, the Russians have been invited in by the Syrian government to assist the Syrian government in its civil war. And so the Russians are there on this basis, which is not explicitly laid out in the charter, as Jack rightly said, but is understood by nearly everyone to be an exception or a permitted use of force. That is, if states invite in another state to use force within their territory, that's allowed. So that's the legal basis for the Russian presence in Syria and use of military force. And the difficulty that presents for us is that the possibility of finding ourselves on opposite ends of a conflict with the Russians goes up significantly because they're assisting the Syrian government. We're assisting the so-called moderate Syrian opposition through generally supporting them, arming them, now increasingly training them, maybe doing more. The more we are doing, the more chances there are that we are going to end up in opposition. And that the case you raised of the attacks on the chemical weapons base is a good example of that. There was some thought that there were Russian troops on the ground, and were you to kill Russian troops in Syria, you could find yourself in a hot war with Russia, and that's extraordinarily dangerous.
Well, that was actually going to be my next question, which is when we attacked the Shayrat airfield, given that Russia was Syria's ally, did we risk being at war with Russia?
Well, we risked it politically, and I think the Russians and the Syrians actually have the upper hand on international law here. They could have viewed that as an unjustified attack, armed attack, to which they could respond in self-defense. And Russia could have claimed acting very much like the argument, but probably with more force, more power that we were making with regard to ISIS, collective self-defense with Iraq. They could have made a collective self-defense argument that they suffered an armed attack and could have responded to that armed attack with necessary and proportionate force. And I think they would have had the better of the legal argument. Now, all of these things may seem counterintuitive, but that's, I think, where the law leads you on this.
Well, I want to go to another issue related to Syria, and that goes back to the point that you raised earlier, Ona, about when does this legal authority under the jus ad bellum end, right? So as ISIS loses territorial control in Syria, the Syrian regime could be said to have assumed more control over that territory. Yet Syria's unwillingness and inability to contain ISIS was part of the predicate for the legality of the U.S. use of force there. So at some point, Ona, does the legal predicate for the U.S. use of force in Syria disappear?
It does, and the hard part is figuring out when. Now, the collective self-defense piece disappears when ISIS no longer presents a serious threat to the Iraqi government. And so once Iraq is able to secure the border between Iraq and Syria and supplies and attacks are not happening across the border, that becomes much harder to justify exercise of collective self-defense against ISIS in Syria. As ISIS loses territory, it does reduce its the justification for attacking it, even in our individual self-defense, although that would really turn much more on the likelihood that they pose actual threats to the United States. And they don't necessarily need to hold territory in order to do that. Al-Qaeda is a good example. Al-Qaeda typically doesn't try to hold territory in the way that ISIS has, and yet has posed, or many think has posed a threat to the United States of direct attack, and many regard that as sufficient to justify self-defense against Al-Qaeda and its associated forces. And so it's not necessarily the holding of territory that's the key element, but certainly it's an indicator that ISIS is losing authority, that's losing power, and that with that decline comes a decline in the legal justification for using force against them.
But going to the question of unwilling or unable, you say territory isn't key. At what point is Syria no longer considered to be unwilling or unable? And is that a criteria for when the legality of U.S. use of force disappears?
As the threat recedes from actual attacks from Syria into Iraq, or from Syria by ISIS to the United States to possible attacks, then you have to shift from unwilling and unable to anticipatory self-defense. And as that threat recedes, at some point, it no longer becomes warranted self-defense because the threat is too obscure or too diminished.
So
where that line is drawn, good luck trying to define that.
So are you saying that it turns not on unwilling and unable, but rather on the nature of the threat?
Well, there has to be a threat that the state is unwilling or unable to control. And so if the threat diminishes, there's nothing for the state to be unwilling or unable to control, and no justification for going in. That's the way I understand the doctrine.
Well, we could spend a lot more time talking about these difficult issues in Syria, but let us turn now from the Middle East to Asia, where rising tensions on the Korean Peninsula are posing a different kind of threat to the United States and its allies, prompting very difficult questions under international law regarding the use of force. So the United States fought alongside South Korea during the Korean War from 1950 to 1953, and after the ceasefire has maintained troops in South Korea. Recently, the North Korean dictator Kim Jong-un has been attempting to develop a nuclear weapon and engaging in some very provocative behavior. In the last 6 months, he's launched a series of weapons tests. In September, the regime carried out its 6th nuclear test, setting off a bomb that was reportedly about 3 times the size of the bomb that destroyed Hiroshima in 1945. The North Korean regime has also conducted other missile tests, for example, firing ballistic missiles over Japan in August and September. And these ballistic missiles are thought to have a range that could include reaching cities on the continental United States. And perhaps even more concerning, North Korea reportedly might arm a ballistic missile with a nuclear warhead within 1 year. President Trump has used very strong rhetoric to describe the situation and said at a speech in the United Nations that the United States has great strength and patience, but if it is forced to defend itself or its allies, we will have no choice but to totally destroy North Korea. And just last week, Secretary of Defense Mattis described the increasing threat from North Korea. Meanwhile, South Korea has begun deploying the U.S. Terminal High Altitude Missile Defense System, and earlier this month, the United States and South Korea have been conducting joint military exercises in waters surrounding the Korean Peninsula. And the North Korean regime has called these exercises rehearsals for war. So this raises significant questions about the legality of the use of force on the Korean Peninsula. And in particular, I want to start with these military exercises that the United States has been conducting. Are they lawful under international law, and can you explain the legal framework for that?
Well, there's nothing in international law that prevents states from engaging in military exercises, as long as they otherwise observe the rules of international law. So they don't violate the territorial integrity of another state without its consent. So my understanding is military exercises are happening in either international waters or waters that belong to South Korea or in South Korea's territory. And so in that sense, they don't violate international law. I suppose in theory, one could imagine military exercises that cross over the line into a threat of force. And, there have been some military exercises carried out by Russia, for example, right on the border with some former Soviet territories that are perceived as quite threatening and dangerous. Nobody has said that they themselves pose threats of force, but they kind of toe up to the line to the point where they create a sense of imminence, perhaps, although no one, again, has claimed that they're sufficiently imminent to trigger an Article 51 right of self-defense. So, as long as they are as described, and all I know is what's in the press, there's nothing illegal about them. Yeah, they are, in a sense, rehearsals for war. But there's nothing wrong with rehearsing for a defensive war, which is, of course, what they are intended to be. So in that sense, there's nothing illegal about it. And they're clearly meant to send a message to North Korea that we're ready and prepared to defend our allies if North Korea were to act itself illegally and a response was warranted. And again, there's nothing illegal about that.
Jack, do you agree?
I do agree, basically, yeah.
Well, let me ask then a more difficult question. And that goes to the issue of whether, without further action in the United Nations Security Council, apart from the missile tests and nuclear tests that North Korea has conducted, could the United States unilaterally attack North Korea? Jack?
So this is a tough question, and it gets to the hard question of the imminence of the threat. And it gets to the factors we alluded to earlier that have been floated in Anglo-American circles about a multi-factor test for when there are high stakes attacks like nuclear weapons or a terrorist attack of large scale, when that is what's threatened, what counts as an imminent threat. And the American and English idea so far, and it's not just American and English, is that you have to consider a variety of factors. I'll read some of them now. The nature and immediacy of the threat, the probability of an attack, whether the anticipated attack is part of a concerted pattern of continuing activity, the likely scale of attack, the result of mitigating action, the likelihood that you'll have other opportunities. This is a hodgepodge of factors. And I think it would be pretty easy to reach the conclusion if, as you said, first of all, they've sent ballistic missiles over Japan. We could engage in collective self-defense of Japan, maybe on that basis already. If they're, as has been speculated, if they're close to being able to put a nuclear warhead on a missile, we don't have, in terms of self-defense, we can engage in collective self-defense of South Korea and Japan. And if they're threatening to put a nuclear warhead on, have the capability of doing that, then it's getting pretty close to these factors that the consequences are so large, and you might not have a window to do it, and that would be more effective. That I can see making the argument, but it's highly fact dependent. And let me say, it really does depend on the facts and really on intelligence that we don't have any access to about what their intentions are, which I hope our intelligence community has. But I have to say, maybe finally we'll reach a disagreement here. I think that legal factors are secondary here. The consequences of engaging in a first strike attack on North Korea of any sort, whether covert or overt, are so momentous and would have been thought through to such a degree that if, again, I'm assuming a rational administration, I'm assuming that Secretary of Defense Mattis is going to be helping make this call, that any conclusion that a first strike is warranted will be based on a combination of factors and judgment that would, I think, satisfy that test. I just don't think we know what the facts are and whether they're warranted yet.
So I take your point, but I just want to push you a little bit on the factors, because I want to ask about how much the time frame matters, right? So, I mean, if there's a time frame of 5 years that's estimated before North Korea could get a nuclear weapon, should that make a difference versus a year?
Yes, it makes a difference on this test. 5 years is a much bigger window. If it's 5 years, then you might not have to go as early if that's the window, because the threat would not be as immediate on average. If it's a 2-month window, I think the test, first of all, I really want to emphasize that the test is not well fleshed out. It's a bunch of factors. They're not weighed. They're not prioritized. But the idea is that if you're going to be suffering a huge consequence on the other end, that you don't have to wait until that happens. You can go earlier. And whether you can, how early you can go depends on a whole variety of factors, including how big is the window of opportunity.
Do you agree with that?
I mostly agree with it. So the principles that Jack is alluding to is a set of principles. If listeners want to look at them themselves, Daniel Bethlehem wrote an article that kind of summarizes these principles, sometimes referred to as the Bethlehem Principles, which is sort of a summary of an agreement between a few allied states. There's no kind of legal authority behind these. They're published under his name precisely because no state wanted to kind of raise it as their central justification for using force in self-defense. And what's difficult about them is that it's a set of principles and it's not at all clear, are they all necessary? What's the weight between them? How do we weigh them? And that's created, on the one hand, some additional detail as to what would be justified for self-defense, but still also a lot of uncertainty about what constitutes imminence under this standard. And obviously a stretching of the imminence standard over what traditionally has been understood to satisfy the imminence requirement, which is that there's effectively no moment for deliberation, that it's the last possible window to act to defend yourself. And the Bethlehem Principles seem to suggest, well, maybe not the last possible moment, maybe a little bit more time, these other things that you weigh into the mix as well. And in fact, Bethlehem, who was the legal advisor for the UK, his predecessor, Michael Wood, and who also worked in the office with him, Elizabeth Wilmshurst, criticized these principles as much too capacious. So even within the UK, there's not wide agreement that these are the right way to think about
But they've been
question.
adopted by the UK now. The UK Attorney General basically adopted them.
Well, what's so interesting is that the UK Attorney General has sort of articulated these as justifications for acting. It's not clear whether the other political branches are behind it.
Oh, I thought he said it was the British view. I thought that was how he viewed it, but I'm sorry to interrupt.
Yeah, no, it's good. They are the closest to having kind of been willing to get behind these principles kind of in a public way. But, it's one country. The US, I think, has in various speeches also alluded to the fact that it effectively buys these arguments, as have the Australians. But that's 3 or 4 or 5 countries out of 193 members of the United Nations. And there's no kind of treaty or other formal legal document that adopts these principles. So we have to be careful about how well defined we think of them. But in the case of the particular question you ask, could we act against North Korea? I think there's a bunch of things that we have to bear in mind. First of all, there is a necessity requirement. So if there are other ways of addressing the threat, diplomacy foremost among them, those should be those should be the first recourse. They also have to be proportional. So the threat to destroy the entire nation that Trump made in the United Nations does not signal proportionality. So it has to be proportional to the threat posed, and probably destroying the entirety of the nation of North Korea is not proportional to the threat that North Korea poses. So that's something we'd have to be cautious about. And I think another element of this that we have to be careful to weigh is that Kim Jong-un is known for blustery rhetoric and for saying he's going to do things and then not doing them. And so one has to be careful about reading too much into what he's saying. Now, as Jack said, a lot of this turns on what does intelligence tell us? And we don't have access to that information. If you had reliable intelligence that suggested that, in fact, attack was coming in the very near term, I don't even think a year is enough. I mean, the Iranians were at a year mark, and I think many would have thought that was, the mere fact of being within a year of being able to weaponize nuclear weapons was not by itself enough. So one would have to have intelligence that suggests capacity, but also desire and likelihood of actually carrying out such attack. Sufficient likelihood that one would be willing to risk all that Jack rightly points out, which is, really starting us down a path that could be extraordinarily destructive, and one would want to weigh very carefully before acting. You'd really want to be quite certain that what you're doing here is necessary and proportionate to the threat being posed.
I want to get at something that I detected in your response, Jack, which has to do with the importance of this body of law in a situation like this. Did I hear you saying that maybe you think law is not that important, that this body of law is not that important in this context?
No. I didn't say that.
Okay.
What I said was, what I meant to say was, there are elements of international law that I think are more consequential and restraining for various reasons. And there's, just like in domestic law, and there are elements of it that are less restraining. And this is a body of law. I'm not saying it's irrelevant. It's certainly not irrelevant. But the use ad bellum is a body of law that's always been a challenge. Nations have found ways to get around the restrictions, especially by putting pressure on the self-defense rationale for a long time. So I was basically trying to say two things. One, this is not a body of law. I'm not saying it's not consequential or important, but it's not as consequential as some international law can be at all. And second, it's a body of law that in some circumstances some people think is not the most important consideration. So for example, in the Syrian strike, that yes, this is true in Kosovo as well. Almost certainly illegal, but nonetheless justified was the explanation. So that's what I meant to say.
Very briefly, Ona, do you have any thoughts on that?
Well, I think that in a particular instance, it's not the only reason one would either act or not act is because the law says so. I do think here the law is extraordinarily important, and it's easy to point to the violations and miss the view of the broader picture, which is that most states are observing the prohibition on use of force nearly all of the time. And it is core to understanding our modern legal order. And it's part of the reason that I think of this as a core obligation and one that we've got to be very careful about not putting at risk.
Well, thank you both for a very rich discussion of this difficult topic. And I'm going to turn the floor back now to Lucinda.
Thank you
so much.
Thanks.
Thank you, Jack, Ona, and Laura, for an excellent discussion that I suspect we could have continued for quite some time. And thank you to our audience. We hope you found this webcast informative and useful, and it's stimulated your own thinking and questions. If you'd like to view it again, if you'd like to share it with others, the link will be available shortly on our website, www.asil.org/Trump. Our next two installments of this free series will be geographically focused and cross-cutting. We'll be discussing Europe, including Brexit, and Asia. The dates and speakers for this event will be announced in the next few days, so please check our website for updates. Thank you very much.